Item number 4.
Yes.
In this case, the Advocate General is present today to take up this matter. So, Your Lordship, I pray that influence of audience will be given to him and upgrade this matter as.
Advocate General will have a right to first audience.
Yes, Lordship.
We are aware of it.
Okay, Lordship. Right.
I appreciate your Lordships. The Lordship, the item number 21, part heard matter, if it can kindly be upgraded as the first item in the hearing list.
Okay.
My Lords, Lordship.
That yesterday's matter.
Yes, Lordships.
Item 1. I have filed an affidavit this morning. I am for the respondent number 10 as per this honorable court's order dated 7/2/2024. I have filed an affidavit this morning. I am told the respondent number 9 has also filed an affidavit. So if both affidavits can kindly be called.
Give a slip.
May I please to Lordships? Lordships, I beg to mention item number 2. Lordship, on behalf of the council for respondent number 3. Lordship, the council has applied for leave. Is seeking for adjournment for 2 weeks, Lordship.
Item 2. In this case, what about the affidavit by the state?
Lordship, I'm informed that the respondent number 3 is taking care of all this. So they have received an instruction. I was informed that the respondent number 3 has received an instruction.
Who is respondent number 3? Director of Social Welfare. Because you see what has happened here. In view of the nature of grievance which is raised here, we had not asked the director to give a affidavit. The affidavit we asked it was to the state to give it.
Lordship, I'm making a mention on behalf of the council for respondent number 3.
But the direction is to state, not to the director. Director may not be a state. It will be the secretary. Although he is a functionary of the state, highest functionary of the state in the Department of Social Welfare, but still, when state is to file. Madam, here, you see, the court took a lot of trouble to the additional provision, yes. You see, on the last occasion, this court took a lot of trouble in narrating the facts in its entirety in the order 28-2. It appears that a lot of money has been given by the central government on account of supplementary, to give effect to the Supplementary Nutritional Rules 2017. But if basic amenities are not provided with regard to kitchen, toilet, access to drinking water, Yes. We were waiting for the affidavit of the state.
Kohima respondent, Lordship. The respondent number 3, she is the main respondent.
You see, today the council is has some difficulty in addressing the court, but the affidavit should have been filed. There's no explanation of why affidavit should not be filed in matters like this.
Lordship, the implementing agency are there. They are,
No, no, we are aware of it.
Lordship.
We are aware of it, but if you see, if you are trying to give to your citizens nutritious food, and in the PIL, one of the prayers is that you provide kitchens, you provide amenities to so as to uh, access to drinking water. Few days back, there was a national news that Nagaland is the first state in the country to have pipe water given to all the households. Correct? But why is this PIL alive then? They are asking for tap water in places where this nutrition has to be given. Still, we have according to this PIL, we still have malnourished children of the age of 6 to 36 months. So therefore, this adjournment on the ground of lawyer is not appreciated.
Lordship, in the way of the matter, Lordship.
So we'll then direct that if within next week, the affidavit is not filed, the director will be here with all the records and answer to the query of the court.
Lordship, 2 weeks time may be given, Lordship. In the meantime, we will file. Request after 2 weeks time. In the meantime, we will file our affidavit on behalf of the respondent to it for.
All sides are represented. Prayer for adjournment is made on behalf
Your
of
Lordship,
the.
Your Lordship, in this matter, we have not received the affidavit filed by the union of the union of the first respondent one, that's Union of India, and the
Who is for Union of India?
Sir Younger what? And also the instructions which have been mentioned in the
Instructions.
last order.
Instructions you will not get because we have already penned down in the order. All instructions are not required to be provided to the petitioner.
Okay, Your Lordship.
Correct. So that is why this court had taken the trouble of penning down 10 pages of order, 9 pages of order, indicating therein the stand taken in those instructions.
And with the reference of the affidavit and the instruction, we're supposed to file the additional pleadings, Your Lordship.
You, Mr. Yangarati, you please give a copy of your affidavit.
I have not filed my affidavit.
Huh?
I have not filed my affidavit.
No, my affidavit is there.
That's it.
Yes, definitely it is there.
Yes, the problem is, Lordship, this, a number of bail were clubbed together. So that has been separated. So I'm sorry,
The affidavit referred in 20 also is represented. The learned counsel for the petitioner submits that affidavit by the Union of India, which is referred to in order dated 28 to 2024, has not been served on our. Mr. Yangarwati, learned CGC shall provide a copy of the said affidavit to the learned counsel for the petitioner in course of the day. Next paragraph. Prayer for adjournment has been made. On behalf of learned counsel for respondent number 3, as his name is reflected in the letter of, in the letter of absence column in the cause list. Next paragraph. The observations of the court in connection with providing of hot cooked meals to pregnant and lactating mothers for a number of 300 days in accordance with supplementary nutrition rules, 2017, has been narrated in the order dated 28 to 2024. Stop. Next paragraph. This court, in paragraph 13 of the said order, the court has recorded that from the affidavit of the central government, it reveals that the state government have been allocated various funds. Stop. The question posed by the court was as to whether the funds which have been released to the state government have been utilized in the manner for which the same have been duly allocated and disbursed. And therefore, the state government was directed to file an affidavit providing details as to how the state of Nagaland is utilizing the funds disbursed by the central government, and further the schemes are implemented. Full stop. Next paragraph. Very reluctantly, the matter is being adjourned today. Full stop. However, with an observation that if within the extended time of 2 weeks from today, the state government fails to file an affidavit as directed by order dated 28 to 2024, the Director of Social Welfare, Nagaland, within bracket respondent number 3, shall be personally present with all relevant records relevant to this case, with district-wise records, so as to assist the learned government advocate in answering the query of the courts. Query of the court. Next para. The learned government advocate shall send a downloaded copy of this order to the respondent number 3 to put him to notice of the order passed today. Next para, list on.
Respondent number 3 is engaging counsel. Counsel appearing for respondent number 3 is an engaging counsel for the department. Engaging counsel, not the government. Apila Santam. She's an engaging counsel.
Engaged counsel. Okay. Just correcting the order. Engaged counsel for respondent number 3. 27. 27/3/2024.
Your Lordship, I beg to mention item 17 and 18, Your Lordship. I have submitted my adjournment slip yesterday.
17 and 18.
Yes, Your Lordship, it's an analogous matter. I'm for the appellant in item number 18, Your Lordship. My senior is indisposed, so if this can be listed after 3 weeks, Your Lordship.
Okay. All sides are represented on the prayer made by counsel for the appellant. List after 3 weeks.
Much obliged.
Yes.
Please, Your Lordship. Lordship, I beg to mention item number 3 as well. Item number 3, Lordship. On
See-
behalf of respondent number 2, 3, and 4, Apila
No,
Santam.
no, once you have not given us the advance notice,
Lordship, the counsel has applied for leave of absence.
Oh,
And
is
the
it?
name is also reflected in the post list.
okay, okay.
Yeah.
Item 3.
Yes, my lord.
Okay, all sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. list after 2 weeks.
Obliged, Lordship.
Right, Lordship.
Yeah, please, Your Worship. My Lordship, I take commission item number 10. Let this matter come up after 3 weeks.
No, no,
So
we are not
back on
adjourning
record,
like
my
that.
lord.
We are not adjourning like that. Unless you give us an advance information, we are not adjourning matters.
My lord, I have not yet received instruction for,
We'll still take it up. Pray for, make prayer when the matter is called. Yes, we'll update the matter of the Advocate General.
For admission.
Item number 13. Yesterday I submitted the adjournment slip, so Lordship, let this matter come up after 3 weeks.
Okay, 13. Also as a representative on the prayer made by the government advocate, sorry, additional advocate general. List after
3 weeks,
3 weeks.
much better.
Right.
May I please, Lordship? Lordship, I beg to mention item number 6 on behalf of respondent number 7 and 8. Counsel
No.
for respondent number 7 and 8.
No,
Lordship, here I was informed that he had a heart surgery and he went for review. So kindly list this matter after 2 weeks.
item number,
6, Lordship. On behalf of counsel for respondent number 7 and 8.
okay, also as a representative, it is submitted on behalf of Learned Counsel for respondent number 7 and 8 that due to his medical condition, he is unable to appear before the court today. So prayer adjournment is allowed. List after 3 weeks.
Yes, Lordship.
Lords, may we have a fixed date for this? I beg to appear for the appellants in the matter. Can we have 2nd, 3rd, or 4th April, if it's convenient to your lordships? 3rd April is fine. my lords.
3rd April, okay, 3rd April. Okay,
Obliged, Lordship.
For admission, item number 4.
good to see you physically. You appear to be weak. You appear to be weak.
Little bit. Had a small fever a few days back. Otherwise, no problem. I got over it.
Yes.
Please.
My lords,
Yes.
I messed up on the dates, my lords. May we please have 4th April if possible? Or in fact,
Division, normally division bench are taken up on Wednesdays.
my lords, Wednesday we can have on the 17th April if it's convenient to my lords, or 24th April.
17th. Okay, make it 17th.
Obliged, my lords. I apologize.
Yes.
Please, my lord. The limited issue in this matter is the election to the village council. And in this respect, we may just go through about 3-4 provisions of the act, which are relevant for appreciating the case of both the parties.
Sixteen, 17, 18, and 20.
Please. Now, the very purpose of this act
You need this act. Village. What is the name of that act?
Nagaland Village Council Act,
Nagaland Village,
1978.
Nagaland Village Council Act. It will be in which volume? Can anybody tell us?
Yes, yes, no.
Yes.
Please. It's basically an act to consolidate the law relating to the constitution of villages in Nagaland and for a regulation of their duties and functions. This is the primary objective of the act. So there is an election to the village council once in 5 years. That is given in section 6A. 5 years. Please. The whole case revolves under section 4. This entire case, section 4. I'll read it for your lordships. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages, the same being approved by the state government. That's enough for our case. We are not concerned with the remaining portion. There is unanimity between the parties that this is a mandatory condition and it has to be followed. So the fact that the election that was approved by the government, which is the second portion, on that there is no dispute. Government approved it. The only question is, did the concerned parties comply with the customary practice or not? That's a short question in this case. On 18th March 2021, there was a notification for dissolution of the village council . and also for conducting the fresh elections. This is page 88 of the petition, my lord. 88 and 89. These communications are there. So according to this, the whole process should be completed by 31st of March 2021. That was subsequently amended to 30th April 2021. So that is the date. Then my lord, on the same day, or maybe 5 days later, that is on 23rd of March 2021, at page 91. My lord is correct. One of the head GVs submits a letter to the EAC giving 5 names. So the election is for each clan. Now, I will read this letter. It is a very important letter. Forwarding letter for formation of new VCM. Based on the government order dated 19th March, in regard to the formation of the new VCM for Botsa, I hereby present to you the name of the new VCM for the tenure from 2021 to 2026 for your kind necessary action. Now he gives the names 1, 2, 3, 4, 5. So what in effect is he doing? I am giving 5 names. That's it. Now, according to the customary practice, they have discussions, the various clans, very peaceful atmosphere. Then they select basically by raising of hands. But these are documented only to establish that those who participated in it, they endorse the various names. Otherwise, the mischief is, suppose the head GV gives 5 names of his choice, then you will be without a remedy. I mean, in this case, unfortunately, this HGV simply sent this letter without any endorsement, without any signature of anybody. He just picked up 5 names and sent it and said, go ahead. Well, this was going on, and since the time was extended, 5 more names surfaced from these same clans. Yeah, take it. This, my lord, is at page 172. I will just give a small description of this letter. The members got together, identified 5 persons, took their signatures, endorsements, discussion details, and handed it over to the same GB. What he does, he refuses to accept it. He flatly refuses to accept it. This refusal is shown in the affidavit filed by some of the respondents. Kindly see page 211, my lord.
211.
211. He says, after 26 March, the names of the private respondents were sought to be submitted to the respondent number 10 by some villagers, but he refused to accept the same because by then he had already submitted the names of the new village council members as per the directions given to him by letter dated 9th March 2021.
This is affidavit in opposition by
This way.
by
Petition.
respondent numbers 1
It's
to
by
6.
the petitioner itself, the contesting party on the other side.
Respondent number 1 to 6.
Yeah. Affidavit in reply by the petitioners to the affidavit in opposition by the respondents, 1, 2, 3, 4, 5, and 6. So it is the other side who got their names squeezed in. Their admission, yes, 5 people did give, but it was not taken by the LGB. Now, my lord, I just wanted to give a background as to where all the violations took place. Kindly see this letter at page 172. Now we will be able to understand this letter. 1 2 3 4 5 and 6. So it is the other side who got their names squeezed in. Their admission, yes, 5 people did give, but it was not taken by the LGB. Now, my lord, I just wanted to give a background as to where all the violations took place. Kindly see this letter at page 172. Now we will be able to understand this letter. May just read it. That Botsa village has a prevailing customary practice of choosing VCMs clans wise. As such, our respective clans have chosen us to be the VCM for Botsa village council. A copy of a mandated selection enclosed. Mandated means according to the customary practice, all what has to be given. Our respective claims have duly given a copy of a selection as VCMs to the head GB for further necessary formalities with the government. However, against all ethics and followed practice, to our utter surprise, the head GB has rather than forwarding our mandate, forwarded an unmandated list of VCMs according to his own whims and fancies. Mention may be made that the head GB is the GB of such and such Khel, whose own Khel has complaints against him, rejecting his GB of the Khel. The head GB is a government servant against whom there are disciplinary proceedings. We need not worry about that for the moment. But the fact remains that they have in writing said, we have complied with everything. We gave it to him. Instead of accepting ours, an unmandated letter he took on his own, he signed and he gave it, and he refused to do it. So when this went to the concerned authority, then they gave direction. So
Just a query.
yes,
Uh, See, the impugn order para 38, impugn judgment, para 38.
of the judgment, madam.
Yes.
Please, madam.
It will be, page would be
Please, madam.
261.
Please, madam.
Here, there's an observation of the court, last 5 lines of this paragraph. It is thus clear that the respondents in their affidavit has only made an effort to unduly justify the verification report by supplementing with grounds and reasons non-existent in the verification report. The state respondents, therefore, by their affidavit cannot be permitted to traverse beyond the verification report brought out in the letter dated 6/5/2021.
I will answer. I'll definitely answer that. I'm just coming to this.
No, it's okay. This is the query. You can take your time and respond.
I'll answer. I have to answer.
Ah.
These are my objections. As far as these observations are concerned, my objection. Now, my lord, they all assembled there for the meeting on 6th May. This is the fact. Now, on 6th May, when they assembled, there was proper security. The magistrate was there, officers were there, just to prevent any untoward incident, which in the normal course does not take place. When they reach there, the factual position is, they realize, because they are given a document without any supporting papers, so they knew there is no scope for them to sail through. This is the fact. So virtually what they did, they boycotted that election. It's not my case. In writing, they have said that. I linked the two links and try this on this. This, my lord, can you see? Finally come to 115. May I read it, my lord? Only few such letters are there, and then I will come back to the point. As per your order of 3rd April for verification process for the formation of VCM, all the clans of Botsa had come to your office for the same. They had all reached the office. There is no impediment as far as reaching the office is concerned. Then, however, there is an endorsement of Kohima village council in the process. There is a neighboring village for creating chaos and undesirable situation. Kindly mark the word, chaos and undesirable situation. In any election, there will be some chaos, it does not go with the flowers as long as there is no violence. Then, my lord, so you are aware, it is clearly mentioned in the Village Council Act of the government that every village council shall have full powers to deal with the internal situation and function. To such, the enforcement involvement in the process of the direct challenge and infringement of both village council's powers, which is unlawful and violation. The administration failed to deliver justice. As such, the Botsa clan shall withdraw from the verification process. So they said, we are going to withdraw. They went with their list. They could enter the office. They said there is chaos and withdraw. So this is the first thing which has happened. Having made this complaint, exactly after 12 days, that is 17th of that month, which is at page 117, my lord. You know, you got it? 117.
Yes.
Same person. He realizes that the first complaint is not too good for consideration. So he wants to add a little more masala after 12 days. And I will just read out what is not there in the first, what is there here.
This is of which date?
This is of 17th of May 2027. We can show this from the affidavits on record.
17, 12.
17th May
17
2021.
May, huh? Yes.
May I read it, my lord?
Yes.
Clarification on withdrawal from verification. Now he is clarifying that withdrawal of 6th May 2021. He doesn't make any statement. With due respect, we on behalf of the general public of WhatsApp would like to state a few lines. As per the order of the CAC, all household heads of WhatsApp were informed to report to the EAC for verification process of promotion of VCMs. However, on the said date, the people of Kohima deliberately arrived, kindly see, blocked entry of genuine household heads blocked who were in favor of WhatsApp nomenclature. Their participation in the verification was disallowed, and also 4 of the WhatsApp members were brutally beaten by Kohima in the presence of the village leader such and such ESC. This is the first portion. Second, therefore, sir, the overt cruelty and illegitimate infringement by the people of Kohima, which is also a direct challenge to the law and order administration, failure of administrative concern, has led to the withdrawal of the members from the verification process. Now he is giving a reason because 4 people were beaten up, they were prevented from casting their votes. He is giving a clarification to a letter which he gave, in which nothing like this is mentioned. Then, my lord, you might have received the reports of the verification. However, as called by the website will not accept such intimidation. We look forward to your personal examination. Fix another date for reval. Whole purpose was they wanted a date for re-verification. Then, my lord, they give another complaint. This is on 30th of June. All these dates, I will put it across with the affidavit. In this affidavit, they glorified their allegations further and virtually made it as the basis for filing the petition in this honorable court. My lord has seen how they are moving from one to the other. They themselves say we withdrew. Reason was withdrawal was the first complaint, which is neither here nor there. Then it is padded up by 2 subsequent complaints. This one is even more notorious. Many things they have made allegations. No, in simple instance, 4 people from Botsa village were assaulted. So Botsa village, if they know 4 persons are assaulted, they should produce the name of the 4 persons, at least. If they were assaulted, there would have been record to that extent. If they were assaulted, they would have filed a complaint with the police, nothing.
It may not be. You see, if we, in a lighter tone, we take the name of one of the superstars, let us say Sylvester Stallone.
No.
He will not report that he has been beaten up.
Correct. But the fact is, when you are saying 4 people have been assaulted, and you are telling this when? 13 days after the initial complaint. Kindly see this. I'm not speaking from criminal angle viewpoint, but I'm just saying that a metamorphosis of their allegation is going on from stage to stage. So ultimately what happened? It came to light, according to the affidavit of the Home Commissioner, apart from that first letter, they did not file any endorsement of any party or the signatures of any party before the government. So when they filed this petition, what they did, they came up with an ingenious method of manufacturing documents. let me take it for the sake of arguments that he submitted all these letters. Let's take it. Let's not enter into a discussion. What's it? So we'll have a look at it. Kindly see page 93, my lord.
Just a moment.
Please. Now, if you see page 93, they are typed copies. Can you see, my lord? As per the endorsement of Botsa village for the reconstitution of village council, Rio clan has selected Mr. So-and-so to represent the clan as village council members in the reconstitution of Botsa village council. So like this, from 93 to 97 are the typed copies showing that they have done the needful. Thereafter, from page 98 onwards, they are filing the so-called original document. I want the Lordship to kindly see this. Lordship has seen Rio Clan Botsa at page 98, my lord. They have given the name of many people. Interestingly, these names, if you have a look at it, are written by the same person. The signatures of that person is also not there. Nothing is there. Kindly see. So, to show, sometimes when you commit some mistake, you try to rectify it, and then in the bargain, you get into more trouble. So, they didn't have any document. They said, okay, in the court, what is there, let's file it.
No, incidentally, similar issue came up before the bench in the principal seat.
Please.
And similar accusation was made that the handwritings are similar. To that, I had a, to that, this is only to assist you.
Okay, thank you. I'm grateful.
You see, for similar handwriting, I had a query. When I was in my school, in Gauhati, there is a girls' school. And in that girls' school, almost all the girls have a similar handwriting. Because in that school, the emphasis is given to cursive handwriting, and the handwriting of the girls of that school is uniform, by and large, during my times. I can't say about today, but during my times, those handwritings were similar because they gave much stress on cursive writing, and students used to get punishment if they couldn't write in the appropriate cursive writing manners. So therefore, the handwritings were similar. So it is quite possible that in this village also they have very
And
they give emphasis on good handwriting, and therefore best handwritings you'll find in this village is a possibility. We can't deny that.
let me accept that. Let me accept that. No, where he could not fill up, he has to have the signature of these persons. He didn't take. And this is. No signature. See the next page, my lord, 99. That is the way the documents are presented. Name, designation, signature. The right hand side is the signature.
Okay.
Fully blank. So even if I agree to that, which may be a possibility, many people have, when you are bringing up together, like I had the worst handwriting. I could myself not read it. So one big task for me was how to improve it. So I took a lot of pains to slowly write. Not that I've improved too far, I'm much better than what I was there. But the person from whom I copied, that person's signature and handwriting might have very identical. That can happen. So the ultimate test here is the signature. We are making an endorsement. So he is not just an empty post box. He has to collect valid documents. Now, my lord, see page 100. Same portion. Hundred and one, 102, 103, 104. Now come to 105. Here signature is there. So apart from this, I'll come back to this document that will satisfy your lordship on what exactly is the defect with this. So this clearly establishes that what the Home Commissioner said in his affidavit, I'll draw separately, that they didn't submit anything beyond that. Now these officers, they have no interest in the village council election. It is not their case. They are siding with this person or they are siding, no. They came into the picture because there were two contesting parties giving different versions. So in the circumstances, what should be done? You have to verify. Though verification has been shown as a violation of the customary law, the learned single judge in the judgment has affirmed it, that verification has to be done to find out. No, my lord. We'll have a small look. After this, I won't be showing any more documents, my lord. I know my lord is quite fed up of reading these documents. Just bear with me for a minute. Kindly see, my lord.
Am I so expressive?
My lord?
Am I so expressive?
No, no. I meant that we keep on seeing the documents. So many things are being made up. It starts with one, then it expands into two complaints. Then they make a trial of one paper with no signatures. Then as it gravitates after 2, 3, 4, they learn the technique, you have to put the signature. That is also done. That's why I said that I presume that he had given all this at that time. It would still mean non-compliance of the customary practice. So where is the violation of customary practice come? It come from these people. And I have been non-suited, that is the other parties, on the ground that we have breached the customary law. And as far as the villagers are concerned, their dealing in the villages in such manners is very friendly. Normally you won't find violence. They do it in a very peaceful way on faith. So the real issue here is a man who has taken the law into his own hands. If he can derail an election today on the basis of these fictitious documents, then a wrong message is sent to the village people that whatever you do, you can get out. Like if your lordship were to see many cases of hanging, sentence before 14 years. So the criminal knows that if my case comes like this, I can get out. So they get educated. We don't want the purity of the village council system to be impaired. That's all. That is the whole thing. And when these officers don't have any axe to grind, you can't just blame them. Now kindly see page 174, madam. These are the documents of the appellants before your lordship, a part of it, the respondents. Kindly see 174, madam. Now see, just read it, this. 29 such and such. You know. That is, the type portion is at page 176. The same thing, type portion is at 176. Tells us the 29th March 21, ni botsa, ni and all these things. So what does it mean? It means it is a clear endorsement by the people who are participating in it, not only whose names are there, they have signed clearly against each name. So this is an authentic document. If instead of accepting this as an authentic document, we can't non-suit them on the ground of this list and that list. Yeah. They have not manufactured it. It is not their case we manufactured it. Page 180. We have signatures of everybody. One 180 and 181. what I have pointed out to your lordship, my lord, at 180, 181, the typed portion is at 182. Same thing. Then at page 184 again, another plan. Everybody has signed. And typed portion. Yeah, is in the next page. 185. Then again, in Kenshik plan,
Take a seat. Take a seat.
page 192. Typed portion is at 194. Again at page 197. I think it is at 185 or so. So therefore, what is apparent, because this case depends upon the veracity of whatever is submitted by each party. So one party submits the document without the attending documents. He files it for the first time in the court, but that also does not satisfy the customary practice. So straight away, his consideration doesn't exist. Then when he found that things are not too good for him, he had not manufactured these documents at that time. He said, I will not consider it. Give me another date. While the other party, who genuinely submitted the list to the same GP, who is under an obligation to accept all these things and send it forward, he is not the adjudicator of these documents. He will see if it is in order, everything, whatever it is, he will send it on higher. He refused to submit. This resulted in these people having to go directly to the concerned officer, who in turn directed the ESC, go and conduct a verification. And it is this verification which was conducted. At that time, these people ran away. The list was given. It went on in the government from the ESC to the deputy commissioner, additional commissioner, ultimately the commissioner secretary, government. They approved it and they sent it back. So their contention is they were not allowed to participate because of all this turmoil. Let us go by their later documents. But the fact is, they prevented these people from participating. So the violation comes from them. We are victims of that violation. But because we pointed out all these things threadbare, it went to the correct hands. Now, my lord, I'll just have a brief look at the impugned order. I'll satisfy your lordship's two lists and all these things. Before we get into it, just a look at section 4 of the Village Council Act. maybe. A village council shall consist of members chosen by villagers and in accordance with prevailing customary practices and usages. The same being approved by the state government, provided the hereditary village chiefs, etc. So in the light of these facts, can it be said that these people whose application was rejected by him, they are violators? No, they have complied. They gave all documents. He is the one. And he is a person with colorable antecedents. Though I am not delving into it, my learned friend may say. There are some allegations, etc. We are not really concerned with it. But in this type of situation, you cannot change the whole picture. One of the basic points given by the learned single judges is when I go through the list of people who have participated, there is lesser number of people. So because there is lesser number of people, their allegation that they were prevented is correct. No, we're not in this type of elections. We don't have nota. So many people should vote or something like that in the bill. Whoever comes with a few, he will be selected. So to connect that with their allegation, there are say 60 people, 30% are participating. You see the general election of party who rules for maybe a few decades, they did not get more than 30% of the average what they ruled. So it is not the quantum of seats. You can't link it with an allegation of the party.
Best example is Khar in Bombay.
Well, correct.
Voting pattern does not exceed 30 to 35% of the total electorate. One of the most posh locality in the country.
Those changes will come on a larger platform. What happens is, just like the South Indian film stars who entered into politics, they say we need only so much. And our so much are these people. I will cater to them and I will win. So it was not a unanimous decision of the people. It was a decision of a few of the people. And that is what mattered. When you have a multi-party system, each one walking about with a few seats, then the system gets clogged like this. But in this case, incidentally, it is not that it was a microscopic minority which participated. Large numbers are there. We'll read out the figures also. Therefore, now I will take your lordships straight away to the judgment. And before the judgment, yes. I'll start from para 28.
Just
If your lordship wants me to read the full judgment, I can
no,
give
no,
you.
no, no. Just read the
I'm
relevant
just
part.
seeing what is relevant for our case for your lordship to appreciate. Very
Yes.
para 28.
That is which page?
Page 255.
55. Just. Just a minute.
Please.
Just 2 minutes. Just 2 minutes. Supplementary file. Is it in supplementary file? Mistake. This is mistake.
The other one, late petition.
This, I'm sending this file. This is the copy of the red petition. This is only, before I show this, just a background. Since I was all throughout a trial court lawyer before, so this, we are showing it to you. In the back page, you will find signature, and this page you find signatures. Now in the writ petition, in the writ appeal memo, if you compare it with page 105, signatures even of the Gauhati is not telling. I think there in the writ petition is page 56 or 55. Yes, these are the signatures. 105. First signature is of the Gauhati. Even his signature in your Vakalatama back page is not telling. Back page of Vakalatama. Back page of Vakalatama.
There's a signature of Mizozu, the Gauhati. The
No,
Gauhati.
but see the back page of Vakalatama.
Yes,
Signature does not
I found
match.
that.
Signature does not match.
Lordship, this is the signature of the
No, we
Gauhati.
don't know. You, because of the submissions made by the Learned Advocate General,
Lordship.
that these signatures did not inspire confidence. You see, amongst other signatures which are there in Vakalatama,
Lordship.
a similar name is found at page 106, serial number 29. Now he writes a different name. His surname has been written here in this signed copy, Kezo or something. Now that signature is also not telling. Name is same. Down below, you will find that. Page 106, serial number 29.
Yes, Lordship.
Naizadu
Yes,
Kezi or something.
I
Kezu.
found them, Lordship, but in the Vakalatama,
The signature does not tally.
this appears. Whether it's the same person or not.
No, we don't know, but name is same. Clan.
Lordship, this just one thing, Mala. Lordship, the Honorable Single Judge has also not approved our list. Has not also not.
No, we'll come to you. We'll hear you. But we are just trying when we are pitted with the argument of the Advocate General, we just try to compare it. Apparently, two signatures they are only there. Other names at page 105 are not there in this Vakalatama.
3% from each clan has come.
No, we don't know because we have this signature page at page 105 only, 105, 106.
Yes.
So we are trying to just compare it with the people who have come to court.
Yes.
Try to match their signatures, their signature doesn't match.
Yes. Lordship, and sometimes, Lordship, the people have different signatures also. And Lordship, that's most probably that was the reason for the verification.
No, we don't know.
But
we don't know. We are not. We are not jumping into conclusions.
Yes,
We are just
yes.
looking at facts right now. Yes.
I don't know, I mean, page 255.
Yes.
27. I'm not repeating. That's just the ingredients of section 4. No, let us assess, look into the findings of the learned single judge on log. Para 28, both the petitioners and the respondents are in unanimity that the prevailing customary practices and usages in the village is that the respective clan members, after due deliberation, chooses and selects one member each from the clan and informs the head GB of the village, who in turn forwards the names to the government for approval and appointment as the village council member to constitute the village council. So this is a finding that this is the procedure which has to be followed. When we speak of section 4, interpretation of section 4 is given by the learned judge, and this is the view of all the parties, and this is the practice. The Bossa village has 6 clans. The only disagreement is the representation of 0 clan in the village council, as it has only 2 households in the village. This is a clan, my lord, which has got only 2. So they said you can't give them a council membership for 2, but there is no statutory prohibition. So they were all accommodated. Anyway, that doesn't change the nature of the case. The petitioner claiming that unless a clan has 8 to 10 households, such clan cannot have representation in the village council, while the respondents dispute is the same. The admitted position, however, is Zero for the first time has representation in the village council. This disagreement as to whether Zero clan can have representation in the village council is, however, not the issue for deciding the present case, so we'll leave it at that. 29 minutes. My lord, for 29. The center of controversy in the case is the letter dated 6th May 2021, annexure N to the petition, written by the extra assistant commissioner to the additional deputy commissioner, Kohima, submitting the verification report on selection of the VCM by the different clans of Bossa village, where respondent number 7 to 12 are said to have proposed and chosen VCM by the respective clans, and it is on the basis of which names of private respondents have been approved by the government. So here is a typed copy of the letter. It is reproduced there. And the verbatim copy signed by the officer. That is also on record. There's same thing. So I need not go back to that. Finally, see the subject. Subject of verification report regarding clan representation of Bossa village for selection of VCMs. So what are they supposed to do? They are supposed to verify the clan representation in Bossa village, for which whoever wants to contest, they will have to participate. So it's not that 1 list and 2 lists. I will come to that. Then, with reference to the subject stated above, I have the honor to state that the undersigned issued a circular on 3rd April for verification of the claims representative of clan of Bossa village for selection of VCM to be held on 6th April. I would like to take the following verification reports. The Rio clan has 63 number of bona fide tax paying households. There are 31 members present, and all were in favor of such and such. Just pause for a minute, my lord. Out of 63 persons in that clan, 31 came. Almost a large number. Next, see, my lord. The CL clan has 24 members. There were 11 members present, all were in favor of such and such candidate. Then, the Kensi clan has 53 members, 24 were present, all were in favor. Zumu clan has 36, 15 were present. The Sancho clan has 21, 6 were present. Zero clan has 1 member, and their name does not appear in the list. For the first time, the higher authority may give further directives. Now, the finding at page 31. I'm sorry, para 31. May I read?
Yes.
A perusal of the letter dated 6th May 2021 clearly reveals that in the verification report conducted by the EC on 6th May, only 31 out of 63 members. You know, there's a dissection of how many people came. Verbatim repetition of what has been mentioned there, but I will read it out. The Rio
You can omit that part.
I think we'll omit that. This paragraph itself, because it's a repetition of that. It has already come. Only inference is large people did come. From the letter dated 6th May, it is proved, perceived, majority household of different clans of Bosta village, barring Thiru, did not attend the verification process. Majority did not attend, and the private respondents were chosen as village council members by the minority household of the clan. Where is minority household? Then, my lord, this certainly raises the concern of the court and leads credence that the group supporting petitioner 3 were opposing the change in the name of the village were restrained or prevented from attending the verification process, and the charge were allowed to enter the office and report. How can you can come to a presumption when there's concrete evidence to show that they have backed out? They are saying we are withdrawing. Once they say we are withdrawing, that is the end of it. 1 list, 2 list, everything doesn't matter. Because they are saying we are withdrawing. Now, just to say that the number of people who came for the voting was limited, a minority, 1. 2, that is being corroborated with the allegation of the petitioner that all these things took place, while the letter written by them of 6th May 2021 does not damage the situation at all, except for the subsequent improvements. So this may not be right, in my humble opinion, to come to the conclusion and say there is less numbers, so this is it. No. Then, my lord, then we come to para 33. May I read it, my lord?
Yes.
Both the council for state as private were submitted to the verification for choosing the council members was peaceful, and no member of the clan were prevented from taking part in the verification process. Submission made by the council that there was information about some commotion outside the EA office corroborates the petitioner's account. There was a clash outside the office and they were preventing the petitioners from entering forward. No, my lord, what is held here is what the learned council only said, that there was some commotion there. Now that commotion is linked to the allegations being made by the original petitioners. That is because they were not allowed to vote and there was violence. We cannot come to these type of conclusions. Presumptions also have their limitations. When the evidence on record is quite clear, I don't think we should resort to the appendage of presumption. And here it is very clear. Next, my lord.
We'll just take 2 minutes break and come back.
have some medicines. It's not a time. No time for that. Maybe just for medicine. Oh, first. So it's just a drop.
I'm keeping all this low cutting later.
You were at para 33.
Please, sir, I'm sorry.
No, it's okay.
33, I will just go through. That both the council for the state as well as the private respondent submits verification for choosing the village council member was peaceful and no member of the clan representing the household so prevented from taking part in the verification process. Submission made by the state council, there was information about some commotion taking place outside the EDSC's office, corroborates the petitioner's account. That there was a clash outside the office as persons from such and such village were preventing the petitioners from entering the ESC's office. Over and above, close look at the attendance sheet signed by the head of the household of the clan who attended the verification process and the letter dated 6/5/21 containing verification report, which is annexed to 14 series of the government affidavit, makes it abundantly clear and irrefutable that only the head of the household of the clan supporting the membership of private respondents were allowed to attend the verification procedure and choose the museum. The number of signatories in the attendance, which is replicated by itself, explains that only names of private respondents chosen by the signatories were forwarded to the government. So again, my lord, it's the same type of finding that your number was less and the council has said there is a commotion. So because there is a commotion, then that person is, whatever allegation he has made, they were prevented, that is true. No, my lord. We have to go by the principles of evidence. And there isn't any material on record to establish these facts. In fact, the documents on record filed by that person itself on the day of this incident establishes the fact that this finding cannot be looked into. This finding has been looked into on the basis of the subsequent two complaints, which were not there, of 17th of May and 30th of June. 30th of June, my lord, if I'm not mistaken, it is a complaint come after 6 weeks from the incident. You cannot presume on this basis. Further, next para, my lord. A conjoint reading of circular of 31st April annexed to the petition and the verification attendance sheet to the government demonstrates that the time slot given by EAC in the circular 3rd April to the different claims of the village for verifying the rival claims on 6 was not adhered to but was randomly fixed at 11 o'clock. And during which only the head of the household or clan supporting the candidate as were allowed entry. Number of persons reflected in the attendance sheet and the verification makes the findings very obvious. It's a repetition of these presumptions. It is therefore evident there was no deliberate verification. You cannot come to the sweeping comment here. It is evident there was no deliberate verification for choosing, selecting VCMs of the village with the involvement and participation of all. This type of statement, actually, these officers have nothing to grind in this matter. They are just government servants doing their duty as directed. They didn't take the law into their own hands. They maintained a peace. There was no violence at all. Nothing. To make a sweeping this thing that they didn't do it, no, my lord. That is unfortunate. Then, my lord, it was therefore imperative. May I read it, my lord?
Yes.
This is very important, my lord. It was therefore imperative for the EC Bosta to have conducted a fair and impartial verification to ascertain as to which of the rival group had the majority of the support to be chosen as the representative of the clan. Full stop. So here, there is an admission that these officers have an obligation to conduct the verification. The main thrust of the other side was he doesn't have any such powers. By doing that, he is conducting the elections. So because he is conducting the elections, it is violation of section 4. This is the other party's case. Whereas here the court itself categorically states that they have a duty to verify it. Maybe the court has given a finding that they didn't do their duty for whatever purpose, not based on any evidence. No, my lord, I will continue. This process was thrown to the wind for reasons best known to the EAC. Only the group supporting the candidate were allowed to attend the verification and the complete exclusion of the others. Then, in addition, you submit the power to conduct the verification is on section 22. So section 22 is a section which gives power, control and superintendence of all these councils from the EAC up to the top level. That is why they are asked that you go and verify. What are they doing in this process? They are not conducting the election. Whatever has been done by the villagers. They come with the list. They want to know whether, because there is a dispute, are the parties present, whose party is present, that's it. Nothing else. They don't participate in the election process. Election process is done. Then they come here. Now, my lord, there is no dispute under section 22 subject to the general superintendent. The administrative authorities prescribed in section 22 have control of all the village councils within its jurisdiction. Such control by the administrative officer in the considered view of the court shall, however, be exercised to achieve the object and intent of the act, but not in derogation of the law. In the instant case, private respondents were chosen as the village council by an unusual method. Unusual method. In contravention of the mandate. What is that unusual method? They have given to the HGB the list, correct list. The HGB accepts, he got the list. He doesn't say while giving the list, it did not contain any of these things. He's not saying that. But he said, since I've taken one list, I will not take one list. So where is a violation from them? There's no violation, there's only compliance. As far as the other side is concerned, who violate by just sending a piece of paper and later trying to pad it, there is no observation whatsoever in this entire judgment about their conduct, except to state that their interest has been harmed. The actual perpetrator of the violation is the other side, not these people. They were law-abiding people. They went through a process. Even the officers went through the process. So to give this type of finding that it is unknown, it is known, this is what they did. Then, my lord, the other is the Jayalalitha's case. Now, my lord, I just pause you for a minute. In customary law, especially in this type of situation, section 4, they clearly state what has to be done. You have to follow that procedure in customary law. If you don't follow that procedure, that means there is violation. That is the implied meaning of it. So these customary laws were there much before our Privy Council and other decisions came, which says that if a procedure is prescribed, you have to follow only that procedure and it admits of no other procedure. So these are basically customary law tenets, which we are consciously or unconsciously following with respect. So as far as the position is concerned, section 4 is concerned, there is strict compliance with it. If that GB had said that they gave me a piece of paper, it did not contain this, that, and I rejected it, we can understand. It doesn't say that. He gives a different reason, so where I have violated? So we cannot change this way. We have to, maybe somewhere the learned judge may have looked into it from some other way, but I think this may be a more modest way of looking at it. Para 37, my lord. The petitioner's procedure adopted to choose the village members being alien to statutory provisions of law. This court has no hesitation in holding letter written by the ESC submitting the verification report and the consequence of is liable to be struck down. How? One ground. Nothing. Only saying that everybody didn't come, or from his letter, it can be read that they were prevented. They themselves say we don't want to participate. When they are saying we don't want to participate, what grievance they can have about it? Then, my lord, 38. Another factor which needs the consideration of this court for deciding the controversy in the matter is with the respondents in the affidavit have attempted to improve and explain the verification report contained in the letter dated 6 May. The government respondents as well as the private respondents in the affidavit in opposition has categorically averred that the two separate lists of VOCs submitted by different groups were duly verified by the AC and ascertained that the private response has a majority support. Now, my lord, I just pause for a moment. The other villagers don't say that my list contains more number of people. They don't say that. They say we did not participate. So question of somebody saying this or that doesn't arise. They have walked out. Then, my lord, the EACS accordingly resolved the dispute list and the private response 7 in the presence of all the parties. The verification conducted by EAC only speaks of some head of the household, different clan persons, and favoring the private respondents who were the lone VCM candidates from their respective clans. Report nowhere mentions that the two separate lists submitted by the group were duly verified by EAC and only thereafter the list of VCC in support of the petition number 3. This is not even the case of the petition, not the case of petition at all. Then, number 3, 8, 9, and 14, the private response 7 to 12 were resolved in the presence of all the parties. It is thus clear the respondents in the affidavit only made an effort to unduly justify the verification report, supplementing the grounds on non-existing in the verification report. State report by the affidavit cannot be permitted to traverse beyond the letter. Now, to whom does this apply? Correct. You have gone over 6/5/2021. This applies to the other side. It is the other side who gave that paper without endorsement. They didn't give it to the officer. And the officer, Abhijit Sinha, whose affidavit is on record, he categorically says we received only this and nothing else. So they have not been able to change it. And after that, they find out these type of documents one after the other. So the allegations which they have committed cannot be transposed to us without any tangible evidence or record matter, that may not be fair to us. Then, my lord. I'll read this, my lord. State of Punjab. Mr. Bandit Singh. There can be no equivalence saying that every decision of an administrative authority must be composite and self-staining. One, in that it should contain all the reasons which prevail in the still taking decision to arrive at this conclusion. It is beyond given that any authority cannot be permitted to travel beyond the standard adopted and expressed by it in the improved action. If precedent is required for this purpose, it can be found in the celebrated decision of Hill versus CEC. The second equally relevant matter is that when a statutory function makes an order based on certain grounds, its veracity must be judged. This is very important. Veracity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit. Otherwise, an order bad in the beginning will come up later with all these things. Here, draw attention to the observations of Justice Govardhan Das. Public orders, publicly made in exercise of a statutory authority, cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant or what was in his mind or what is intended. Public orders made by public authorities are meant to have public effect and are intended to affect the conduct of those to whom they are addressed. No qualms on this. This is correct. The public authorities, they have given the order and he has given the order right in the title that he is doing the verification. So this type of confusion cannot be imported in this particular case because it is not their case that we participated and we had a larger no. They said later, at least in this proceeding, they were prevented, so they walked out. So one list, two list doesn't stand. The only thing prevailing in the mind of the learned judge, according to me, appears to be that very limited people had attended. That perhaps is the conclusion. And on the basis of that, this is connected with the allegations they have made that they did this and that. This has not happened because if elections are set aside in village councils by these methods, it sends the wrong signal. It means that the fever of municipalities are spreading to village councils. We should retain its security because they look upon these courts only for justice.
Yeah, please, Your Worship. Worship, my kindly see, U.S. Flalia. My Lord, the contending parties, the performer respondent number 8 to 23 in this appeal, who had a respondent number 7 to 12 in the writ petition, my Lord, their appointment has been set aside by the Honorable Single Judge. Yet they have not filed. They have accepted the judgment. Lordship, we had also sought for our appointment on the basis of the recommendation, on the basis of the list submitted by the head GP. That has also been rejected. That prayer has also been rejected by the Honorable Single Judge. What the Single Judge has directed is that conduct a fresh election strictly in accordance with Section 4. And we have accepted. Both the parties have accepted. The performer respondent, the respondents whose appointment has been set aside by the Honorable Single Judge has not appealed. They are performer respondents in this appeal. Therefore, my lord, who is the state? The state, as rightly pointed out, is to only see that the system of appointment of village council members in the state is not improper. Now, Lordship, the Honorable Single Judge, after consideration of all the facts before it, has concluded that there is something which is not.
But you see, let us examine the law.
Yes.
Let us say in a proceedings, you have implemented ABC as respondents.
Yes, Lordship.
First query is, in a litigating system which we are following, do we have a concept of pro forma respondent? Pro forma respondent is not spelled out anywhere. Because even in the High Court rules, or if we go to the civil procedure, it is plenty from the defendants, and in High Court, it is the petitioner and the respondent. So pro forma respondent is a concept I am not aware, although we use it.
Yes, Lordship.
So let us say in a proceedings, in a writ proceedings, parties are A, B, and C, and there is a judgment of the court. Now, can somebody say, as you are arguing right now,
Yes, Lordship.
that out of A, B, C, C could not have filed an appeal?
I'm not saying that. Lordship, they were named as party respondents. They were not named as pro forma respondents in the writ petition. Because the state also was the respondents in the writ petition, because their action, that is the approval of private respondents, was challenged, and the respondents' appointment was challenged. Now, Lordship, the respondents whose appointment has been set aside has not appealed.
We understand that. We
so
understand that.
means-
But what does it mean that the state could not have filed an appeal?
No, I'm not saying that, Malak. I'm not saying that the state can challenge, but I'm saying, look at the person who is supposed to be aggrieved, actually aggrieved, have not questioned, it's not questioning, it's accepting the judgment. But on the merit, Malak, let me just, who has filed the appeal? That is the only, that's the point I wanted to make, Malak. Apart from that, in Lordship, this unanimity, my lord, I have also categorically mentioned in my writ petition, and the respondents also in the affidavit has stated what is the prevailing customary practices of choosing the village council members. My lord, it's clan-wise. There's 6 clans in the village, my lord. So the practice, my stand, the writ petitioner's contention is that the Zero clan has only 2 households. So therefore, unless they have 8 to 10 households, they were not given a representation in the village council. And therefore, in the past, they never.
What will happen to the family of, there's a family in
Yeah.
Mizoram.
Yes.
The head of the family is known by the name of Zion, Z-I-O-N. I'm informed from the newspaper reports that in that village, he only has a family. In that village, entire village constitutes of one family. And incidentally, he has 86 children.
No, Lordship, but here in this village, Malak, in this
No,
village.
but you see, number one, there should be something, some history recorded that in the Naga customary practice, one family or 2 family clan would not be given representation. Because you have to show some document.
Lordship, Section 4 says the village councils shall consist of members chosen by the villagers, in accordance with the prevailing customary practices and usages of the village, of that particular village. Each village has its different customary
Correct,
practices.
but to exclude someone from the from representation, you have to show us something more.
There's something more is in the past, this election or selection took place in March 2021. This was the first time that Zero Clan has been given a representation. Earlier, in the earlier village council, there were no representation of Zero Clan. That itself shows that because of the number of the household, they were not represented. That is one. The other aspect is more, the other custom is that clan members, they sit amongst themselves. Each clan will sit amongst themselves. They'll deliberate and they'll choose a member. And they're supposed to give that to the head GB Malak. There are TGBs in the village. The head GB was asked to give the names by the government, by the ESC. Therefore, the names are given to him. Lordship, it doesn't mean it has to be, the person has to sign and give it. Even that requirement is not there. Lordship, Naga customs was all oral. Lordship. This written thing has come about only now. But Lordship, here, the names were given, but endorsement that these are the list of persons. These are the list of persons who are supporting the candidature or the selection of this person. That name was given to the head Gambura. The head Gambura, along with his letter, listing the 5 names, and the endorsement or the list of persons who endorsed that name was submitted. Lordship, initially, by letter dated 18/3/2021, the EAC was told to give the name by 26. Lordship, may kindly come to the relevant document. Lordship, may kindly come to page 19. Lordship,
1990.
90. This is the letter. This is
Yes.
page 90, madam.
Yes.
May I read it? This is dated 19 March 2021, and this is by the ADC. Lordship, this is written to all the GPs under that particular circle. That's the particular this segment. This finds a notification received from the Deputy Commissioner's Office, white number such, dated 18 March 2021, in regards to the dissolution of all village councils of the recognized villages under Chipiposu subdivision and formation of new VCs. Therefore, you are directed to form a new village council members in accordance with the prevailing customary practices and usage as provided in the Nagaland Village Council Rules 1979 and the Nagaland Village Travel Council Act 1978, and submit to the office on or before 26 March 2021 for almost submission to the government for approval. So, my lord, the date given to the Gambura is 26/3/2021. Now, this date, in the affidavit of the state respondents as well as the private respondents, they said it has been extended up to April. It was extended subsequently after this, it was extended on 31st March. But by 26th, my lord, the head GB was not informed, there's no document saying that the head GB has been informed about the extension. So the head GB gave his name, the list our lists were submitted to the HGB before 23rd, and the HGB submitted the list on 23rd. Lordship, the letter by which the respondents submitted the name to the deputy commissioner is dated 4th April. So the GP says, no, he's supposed to submit it by 26. He's received it after 26. So therefore, he did not accept their names. That is the stand of the HGB. Lordship, briefly, Lordship, why this dispute, why this problem is my lord, the Botsa village is an offspring of Topema village. Topema village is the parent village. The Botsa village was established sometime in the year 1947 by the person who moved out, and the land also traditionally belonged to the Topema village. There's no dispute about it. In 2019, the Kohima village, the parent village, wanted the name of Bosa village to be changed. They wanted to add Tofe before the word Bosa. It was resisted. Public meetings were held. Resolutions were passed that the name given by or name chosen by the ancestors, the leaders of the village, who founded the village, should not be changed. Lordship, the annexures are there, resolutions are there. And that is the genesis of this problem. Now, in 2021, when this came about, yes, there was a section in a village who wanted to change the name, but the majority of the villagers did not want to change the name. Now, when this dispute came about, names were submitted, and after the GB submitted the name to the EAC for forwarding it to the DC, another list was also submitted, but he rejected. That's a fact. He had rejected it because that was submitted. According to him, he was not aware of the extension of the time, so therefore he was supposed to submit it before 26. And Lordship, the endorsements were there. Yes, Lordship, most of them is not signed, but usually, and it is usually, Lordship, in this kind of meetings that we also attend this kind of our village meetings. Well, the person takes down the names, write down the people who are there. They don't even sign it. So that is the practice most done here. So, and actually, Lordship, the act does not require that the names have to be signed, person, all this is just what is the prevailing customary practices. Usually there's no dispute. People sit down, client sit down, chooses the name and give it to the GB, and GB forwards it. That's the practice. Now, according to that practice, our names were given. Now, when the dispute came out, when the complaint came, Lordship, the direction from the DC, it appears that verified. And so therefore the circular dated 3/5/2021 was issued by the EAC calling the heads of the state to his office. Now, when that was done on 6/5/2021. On 6/5/2021, clans were given different slots, different timings to come. The first clan who was supposed to enter, 10:30 or 11, villagers from Kohima were present. Not inside the premises, outside the premises. So the persons are good. They are not allowed to go. The leader, one Rio, T Rio, is also a traditional, managed to enter. There's commotion, there was beaten up. Yes, Lordship. They are not, one was even hospitalized, I was told, but there's no police complaint. Lordship, when they entered, he managed to enter and told the EAC that today the verification should not take place because some outside influence are there and people have been prevented from entering and some has also been assaulted. He entered, he told the same thing. And thereafter, one more person from the same clan managed to enter. And Same thing was said. And in fact, they were told that it is okay, fine, it will be done some other time. They left, entire villagers left, and subsequently, those persons who were selected, their group were allowed to enter, and a verification has taken place. Lordship, if you look at this verification report, and immediately on knowing that, Lordship, there are 3 GBs, of course, saying that as GB should not be a salaried person, 2 has been removed, but if we go by the village council act, only a village council member cannot be a salaried person. It doesn't say GB. And the respondents, as well as the state, has agreed, has said that GB and VCM in the affidavit, GB and VCM is not the same. GB is not the village council member, but they have been removed. This is one of the reasons for siding with the petitioners group, maybe, for saying that this verification has not taken place properly. He has been removed after serving for almost 15 years as GB. One was served for 8 years, one was for 15 years, and has been removed when this issue came along. Now, Lordship, then, as soon as the GB, 2 of the GBs came to know about this, not the head GB, the other 2 GBs, they made the complaint.
The way?
They made the complaint to the EAC that this has happened. Lordship has seen all those, everything is there. This has happened. Please have a verification on the other elements. Since nothing happened, Lordship, nothing happened. Another complaint was made directly to the DC after a few days.
This shows this letter, a complaint made by 2 GBs out of 3. Where is that?
115. Page 115. This is a type copy. Lordship, there's a type copy. Page 116 is the original photocopy. Should I read it, Lordship?
No, this was read. We have flagged it.
Then the second complaint, this was on 6/5/2021 itself, this very same day. Then Lordship 117. This is directly to the Deputy Commissioner. This was submitted on 17/5/2021. 17/5/2020. Lordship, then, if you look at the impugned report 119, recommending the names of the private respondents. Lordship, in the affidavit of the state government, it is clearly said that there were 2 lists, so verify. Therefore, the EAC was directed to verify. Here, Lordship, the EAC has not considered any list. This is not a verification. This is a head count. This is a selection. This is an election. Only one group was present. So now, and out of this, if you go, Lordship, even the numbers, they do not have the absolute measure. Now, Lordship, whether, what is the customary practices? Section 4 now, Lordship. What is the prevailing practices? There's no dispute that the selection of village council members takes place in the village by the clan members sitting in a council. After deliberation, they choose one. This is not the manner in which a village council member is selected. This has been done in a government office. In a government office, in the presence of a government official. Lordship, will it be fair? A thing must not only be fair, but it must also look fair. So, Lordship, here in the presence of a government official, who more probably could be biased, this was done. This has to be done in the village. If there were certain problems, the villages should have been provided security and it should have been done strictly in accordance with the customary practices of that particular village. That was not done. So violation of section 4 again. Now, Lordship, when all this was pointed out through a detailed representation submitted on 30/6/2021, yet, Lordship, by that time, the impure approval letters were already passed. After the two complaints, first two complaints, one on 6.5, one on 17.5, then the impure orders were passed, totally ignoring the complaints, without even trying to ascertain whether these complaints are genuine or not. And Lordship, who are the GPs? The GPs are also parties. Who are the GPs? They say GP has no local standard to file these petitions. Lordship, GB, government appointed, they have to see that the affairs of the village are run in accordance with the rule of law. They also have a right in their individual capacity to select which is VCN. So they say here, of course, today the Lana additional age has not placed that up. It's taken before a single judge that GP will have no local standard to even file this petition. Now, Lordship, therefore, the Honorable Single Judge has rightly held, did not approve my list, did not approve my selection, but also did not approve the selection. Now, all the verification strictly in accordance with section 4, which is in the village itself. In the village itself, in accordance with the village customary practices, if required, Lordship, provide security. There's no harm. It doesn't affect anybody. Why will I shy away? Lordship, I'm saying I have the majority. I will not shy away, Mother. Why should I shy away from a proper selection process? Even the persons whose appointment has been set aside are not questioning it, are ready to face it. Why does that should be worried? Now, Lordship, basically, my Lord, there's no infirmity. In some substance, there's no infirmity in the judgment of the Honorable Single Judge. Honorable Single Judge has taken everything into account, has read the petitions, amendments in the petitions, as well as the affidavit in reply, the documents, everything has been considered, and only then it's a beautiful judgment. It's all the pictures have been taken into account. Nothing has been left out. The pleadings has been gone through thoroughly. The Honorable Single Judge has taken the pain to read the pleadings and the documents, and then only delivered the judgment. And there's no illegality. No one can be aggrieved by this judgment. Now, Worship, section 20. Worship, section 20. Section 20 has been, and ground has been taken that under section 20 once an application or representation is made, it is due. Lordship, can I read? Lordship respond at page. When a dispute arises as to the selection of any member of a village council, the matter shall be referred to the state government, whose decision thereon shall be final. So therefore, it is the decision the government will decide. We have made the representation, therefore the representation is pending, the repetition is premature. These were the grounds taken before the Honorable Single Judge, and the state has the absolute authority to decide. Now, Lordship, this provision has been interpreted by by a division bench of this Honorable Court into the 2015. Lordship, I appeared in that case. I had also taken a similar view like it is taken by the opposite side, but it was rejected. Lordship, section 17, 18, 19, and 20 were read together. 18 says, a seat shall become vacant when a member dies. After the constitution of the village council, Malad, after the village council starts functioning, a seat may become vacant when a member dies, when a member resigns his seats, or when a member is removed by the state government on becoming disqualified. 19 says, when a seat becomes vacant, the chairman shall call upon the village council to choose a member. And 20 says, so 20 is in relation to, or is in respect of a vacancy that has arisen in the scenario mentioned under section 18. Lordship, that judgment, if I may just place a citation. This aspect was not dealt with, Lordship, by the single judge, but it is one of the ground in the writ. Therefore, Lordship, though today it was not pressed, but section 20 was, since section 20 was read, Lordship, this has been decided in 2015 5 GLT, Lordship. 2015 5 GLT 455. 2015
15, 1 5.
5 GLT 455. Paragraph 14, 15, 16, and 17 are related. Lordship, should I read this?
Yes.
Lordship, I'll read from paragraph 14. I read from 14 paragraph. Page 458.
No, so this is
Lordship, that is High Court.
there is High Court. So, down below. It is Supreme Court.
The pair 14. Lordship, paragraph 14 to 18, but may I just read paragraph 18 for the type?
Yes.
Lordship. Having said so, we will once again avert to the provision of section 20 of 1978 Act. Section 20 is preceded by section 19, which says that when a seat becomes vacant, the chairman shall call upon village council to choose a member. A seat may become vacant only in 3 situations visualized in section 18 as noticed above. Under section 20, if a dispute arises as to the selection of any member of a village council, the matter shall be referred to the state government, whose decision thereon shall be final. Therefore, section 20 visualizes 3 things. Firstly, a dispute must arise. Secondly, the dispute has to relate to selection of any member of a village council. And thirdly, in the event of such dispute, the matter is to be referred to the state government, whose decision shall be final. In view of the provision contained in section 18 and 19, the fact that provisions of section 20 follows the provision of section 18 and 19, the dispute referred to section 20 necessarily relates to filling of a vacancy referable in section 19. That is why the word any is used in section 20. As per Concise Oxford English Dictionary, Indian edition, the word any has been defined as referring to one or more of a thing or number of things, no matter how much or how many, whichever of a specified class might be chosen. Black Dictionary, Law Dictionary, Black Law Dictionary, 6th edition defines any as some, one out of many, an indefinite number. Any does not necessarily mean only one person, but many may have reference to more than one or many or to many. The word any has been explained as having diversity of meaning and many, employed to indicate all or every, as well as some or one, and its meaning is given in a statute depends upon the context and the subject matter of the statute. It's also settled proposition that while interpreting a statute, presumption is that legislature will not use any word or expression in the statute unnecessarily. Every word used in the statute carries its own meaning. Therefore, the word any appearing in section 20 refers to a vacancy of seat under section 19. It may be one vacancy or more than one vacancy. In the event of dispute related to selection of member to such vacancy, a reference is required to be made to the state government for its decision. The question is, therefore, arises, he is who shall make the reference. Board features of section 20 have already been discussed. Section 20 deals with a dispute relating to selection of the members to a village council. Therefore, it's a dispute confined to members of the village council and not functioning of the village council. We have already noticed that authority of the village council is exercised through the chairman. As per section 19, which precedes section 20, it is the chairman of the village council who has been entrusted with the duty to call upon the village to choose a member or members to fill the vacancy or vacancies. Having regard to the above, this dispute referred to section 20, therefore could have to be referred to the government if it is so required by the chairman of the village council. Thus, such an interpretation could be in tune with what objective of section 1928, which we have already read above. Now there is motion.
Take a break and resume.
Motion the plan. Should we continue?
Two will continue.
Yeah. Oh, it's okay.
Section 14 to 18. He's saying he's written section 18 first. Shall I read it? Paragraph 18. Having said so, once again, advert to the subsection 2 of the 19th section 20. In order to address section 20, there must be a dispute after formal discussion. After formal discussion. And that should be referred to one by a chairman. Therefore, the need says, therefore, under section 20, government has no selection process. This one. 20 will come as implicit under 18 and 19. Yes. Just short. Therefore, yes, yes. No, also selection process. Whereas this should happen only when sponsor is in session. The difference. So therefore, this judgment is erroneous. So therefore, the facts of this case will be different. Ours is the selection process. Whereas here, members, while they're functioning among the village members, there is a issue. The chairman is referred to. This is the In our case, government service also is what is common. Yes. Yes. Correct.
Small and big house. Oh, yeah. Another 200 items. What's that? Shortcut. Hey, or that's it.
Yes.
The first item 4 will take the entire thing. So if I'm allowed to item 1, it can be possible for the deadline.
Item
1. We have filed our respective affidavits, the respondents 9 and 10. Basic one report is that.
just a moment. We'll have to take this up also because this issue involves the road construction.
Yes, sir.
But this will have privacy. Try to take it up. Just try to understand what is it about.
Therefore, the Honorable Division Bench has said that the Honorable Division Bench has held that Section 20 is only in relation to casual vacancies arising during the existence of a village council. So therefore, this also will not be applicable in our case, Lordship. Now, Lordship, when a village council is existing and it cannot function in accordance with law, according to the provision of this act, then there is Section 54. But that is for dissolution of an existing village council. The procedure is lengthy. When there's a report or otherwise that from the Deputy Commissioner saying that the village council is unable to function in accordance with the Village Council Act, then it can be dissolved. It needs to be placed before the legislature. But in our case, we are concerned with the constitution of the Village Council itself, which is Section 4. Now, Lordship, may I just read some certain paragraphs, pleadings, certain pleadings of the parties. Lordship, can you come to page 65? Paragraph 11, Lordship. Six five. As directed by letter dated 3/5/21, and subsequently not found place, the villagers went to the office of the Executive Commissioner Bossa on 6/5/2021. The other shop expressed that about 150 villages access the extra assistant commissioner complex. They wanted to did not want to change the name of Bossa village when entering the office and participating in the proceedings. And also to ensure that only persons who favor the change of name enter the office and get selected as village council members, or have their candidates selected as the village council members. This led to a clash, and in the process, 4 persons from Bossa village who do not vote but wanting the change of name got it. About 50 members of the Rio clan who were directed by the extra assistant commissioner Bossa to appear between 10 a.m. and 11:30 a.m. managed to enter the office, and their leader, petitioner number 3, told the extra assistant commissioner Bossa not to conduct any proceedings as it would not be fair or just because of the situation created by the managers outside the office, his office. The extra assistant commissioner also agreed that after the Rio plan and after that, Rio clan left. To the same clan who were directed to appear between 11:30 a.m. to 12 p.m., only their leader, such as such, managed to enter the office, and he too similarly told extra assistant commissioner Bossa not to conduct any proceedings, because majority of the Bossa villages will be from entering the office, to which the extra assistant commissioner Bossa agreed. Thereafter, majority of the Bossa villages left. It was subsequently learned that at the instance of the Kohima villages gathered outside the extra assistant commissioners, Bossa office, some Bossa villages who were in favor of the change of name of the village met the assistant commissioner and submitted a list of 6 names for the new village council members. On behalf of the villages, the 2 GPs and the village petition number 1 and 2 submitted a complaint to the assistant commissioner Bossa on 6/5/2021 itself, stating that involvement and obstruction by Kohima villages in the verification process, and as such, the Bossa village plan withdrawing from the verification process, and also make an appeal to fix another date for verification process. The tip is also by another letter submitted on 17/5/2021 on behalf of Bossa villages wrote to Deputy Commissioner Kohima, informing him of what happened when Bossa villages went through the verification process on 6/5/2021, and also requested another. Now, Worship, may kindly see the affidavit, the governments made in the affidavit by the government, by the state, my lord. That is at page 136. Worship, may I read from paragraph 13, page 141. Page 1141.
Yes,
Paragraph 13, my lord. That as regards to the statement made in paragraph 11-12 of the petition, the answering deponent states that as directed by circular dated 3/5/2021, the real claim was first seated in the office of the respondent number 6 for verification, and respondent number 6 inquired from the members present whether anyone is yet to come, to which the attendees had replied that there were none thereby. The verification process was carried out without any outsider influence. In a subsequent verification, it was informed that some commotion outside the office premises are taking place. However, there were adequate security in the office premises, wherein magistrate the Washi and police personnel headed by OC were detailed for monitoring law and order situation, and only those who were in the list paying tax hall were allowed to enter the hall as per the time slot allotted to each class. So, Lordship, here, there's categorical admission that commotion has taken outside the village. We also did not say, my lord, that inside the premises, the security arrangements were made inside the premises. But, Lordship, we have to enter the premises. That was prevented, and so therefore, clearly, there's a clear admission saying that some commotions were there. And Lordship, again, Lordship may come to page 144. 144, paragraph 17, my lord. Paragraph 17. That with regards to the statements made in paragraph 16 of the petition, the answering deponent vehemently denied the selection of the new village council and approval of the government is illegal and is done in violation of section 4 of the Village Council Act. It is correct to state that the village council members had to be chosen by the villagers in accordance with the prevailing customary practices and usage. It is also correct to state that each clan of the village chooses their representative through deliberation among themselves in the village, Worship Makali note that in the village, and thereafter submit to the government for approval through the GPs. So, my lord, this selection has to take place in the village. There's a reason, my lord. Otherwise, my lord, if it's outside anywhere, then there's an involvement or interference by others. The government themselves says it has to be taken, this deliberation of choosing the village council members has to take place within the village. Now, admittedly, my lord, undisputedly, this, though they call it a verification report, that verification report itself was a selection, my lord. Based on that process, the process held on 6/5/2021, these village council members were chosen. So therefore, that is selection, that is election, my lord. The verification process itself was the election. Because then, on that day, Because of that process, so whatever name it may be given, my lord, that is the reason why the name has been approved. And this has not taken place in the village, but in the office of the ESC, in the presence of the ESC. And outside, there's commotion. Why is there commotion, lordship? Why the commotion? Then lordship again. Lordship, may kindly see 146, page 146. The statement made in paragraph next, such as such of the petition are categorically denied to the effect that the ESC also had purportedly conducted first election for promotion in English. The circular dated 3/5/21 issued by the ESC also clearly indicates the verification of museum for formation of both sub-village council submitted by different groups. Although, for the reason best not known to the head GP and the petitioners, many of them did not turn out to participate in the verification process in spite of prior information. Many did not turn up. Lordship, we could not turn up. Only one client somehow managed to enter at 11 a.m. And the rest could not enter the office. So that is the reason. Did they try to find out why? In spite of complaints saying that this is the reason, in spite of giving the reason, no action was taken. Lordship, why? On that day, my lord, today, Lordship may kindly note this. Today, the state is coming in trying to protect the appointment of the private respondents. These private respondents were selected in the presence of the officials, government officials, totally in violation, contrary to the customary practices of the which is selection amongst the village, exclusively by the clan members and within the village. Now, this has taken place outside in the office, in the government office, in the presence of government officials, the washes and other officials, ESC included, and today they come and try to protect this selection. Lordship, when the contestant party, the disputing party, has no issue, accepts that, okay, we'll go and go for a fresh selection, as directed by the Sovereign Board. Why the state, the body, the person who's supposed to, whose only role is to see that rule of law is maintained, the selection is conducted in accordance with law. Why should he file this, be agreed? So when this honorable court has found that there's a violation of the rule of the law, why the state should be agreed when the contesting party has not questioned it? Even my first prayer was appoint me according to the list, the first list. That has been rejected. In the alternative, yes, fresh election. So this honorable court did not accept my first prayer, has only directed that fresh selection take place in accordance with law. There's absolutely no reason why the state should be agreed. One of the other aspect of the is that the file, the affidavit, I filed my replies, whatever steps that have been taken is only there. I would not like to waste the time of this honorable court by reading all the documents.
Want to say something? You want to say something? No, you complete your part, because then he will give a reply later on.
You go there.
Yeah. May I please, Lord?
Yes.
My Lord, whatever the Advocate General has made submission, I adopt that submission. So, my Lord, I represent the private respondent number 18 to 23 in the writ appeal. In the writ petition, their names appeared as serial number 7 to 12. Altogether, 6 of us. My lord, I just take lordship to page 93 of the document in the writ appeal, page 93. The names purportedly selected and submitted by the head GB on 23/3/2021. Page 93 of the writ appeal.
Yes.
Particularly the serial number 19. Serial number 19. Mr. Raju Khile. This gentleman had never attended any meeting for selections of the village council member in support of Tepunito Rio, the petitioner's group. This gentleman had never attended any meeting. Now, therefore, in the affidavit in opposition, I make a specific allegation that it is fraud. My name was stolen. They have forged my signature. Now, in their explanation, they said it is wrongly written your name. If the page 93 is, I agree, in typing, somewhere typing mistake may be there while writing the name. So while I check the typing, Raju Khele he's a medical doctor, who is a doctor of Naga Hospital, Kohima, who had never attended any village meeting. They have taken my name, serial number 19. So therefore I came. No, I had never attended any meeting. I swore on the affidavit. Now after that, I'll take my oath. Now I say, Raju Khele had never attended any meeting. So therefore I say it's fraud.
Your respondent number?
My lord, he is not a respondent.
Okay.
He's not a respondent. He's a village, he's a member of the clan.
You
Rio's
said,
clan.
you said I, that's why we are asking.
Yes, my apology. Raju Khele, he is a bona fide member of Rio's clan, who had never attended village meeting while choosing or selecting the name of Tepunito Rio, who is the petition number 3, read petition number 3. My lord, they say it's a typing mistake. Then I take lordship's attention to the handwriting. In typing, there can be typing mistake, spelling mistake, but in handwriting, it cannot. If somebody write his own name, there cannot be any wrong spelling. I cannot write my name with wrong spelling. Lordship, I take lordship's attention to page handwriting, page 98 of the writ. Serial number 19. Raju Khele. This is purely in handwriting. So if at all I had attended the meeting, I can never wrongly enter my name. My lord, to that effect, this is the handwriting. Typing can be wrong. Handwriting cannot be wrong. In writing, while writing my name, I cannot write my name with wrong hand spelling. Now, to that effect, I have sworn an affidavit which has been annexed in the affidavit filed by the private respondent number 7 to 12, page 198, my lord. Page 198. Page 198. Affidavit, my lord. Sworn by Raju Khele. Page 198. May I read it, my lord?
So we'll not point reading it.
Yes.
We take
So
your word
now,
for it.
by this affidavit, I have clarified that I have never attended any meeting. That means it's a clear case of fraud committed by the head DB and the so-called clan member of Rio clan who supported the candidature of petition number 3. Why I don't stay in village, how can I come and attend village council, village clan meeting, choosing a member to be the VCM? So this is what I have left. Therefore, I say I have made a specific affidavit in the private respondent has made specific allegation that this is a fraud. My lord, and coming to page 94, similar fraud has been committed. Page 94. This is in respect of Sanchu clan of Boxer village. The first one is Rio's clan. This is Sanchu clan, my lord. Page 94, type copy. Here, serial number 18. Serial number 18. Krevizole had never attended the meeting and recommended the case of Villa Hule, who is a member of the petitioner. My lord, even here, in typing, spelling can be wrong, but in handwriting, it cannot be wrong. Page 99. Page 99. Serial number 18. Krevizole. By my signature was forged while submitting the list of the candidates for the petitioners. They want to project in such a way that I also have voted, supported his candidature, which is not at all correct. So this is a clear case of fraud I have mentioned. Now, I'll not take much of time of the court. I'll just take lordship to my relevant affidavit, affidavit filed by the private respondents. Page, lordship, the relevant paragraph is page 155. Affidavit filed by the private respondent 7 to 12 before the read court. In the present appeal, page 155. The relevant portion will be 156, but I'll start from paragraph 8, my lord, paragraph 8. Relevant paragraph 8, my lord. May I read it, my lord? That we regard the statement made in paragraph 7 of the writ petition. The deponents beg to state that as directed by the district administration on
Please continue.
On 19/3/2021, the 6 clans had meeting on different dates and choose their VCMs for the tenure 2021-26. They select list containing the name of the private respondents 7, 8, 9, 10, 11, 12 from 6 different clans was duly submitted to the head GB Bota village by their respective sessional chairman / president / secretary, which was marked to the office of the extra commissioner in brevity EAC Bota circle. However, the then head DB refused to accept the said list for onward submission to the government. Therefore, immediately the representatives of the 6th clan had submitted the same list to the deputy commissioner Kohima and to the office of the EAC. The relevant paragraph below that. In the meantime, this is the relevant paragraph. In the meantime, after refusing to forward the private respondents list of VCM by the then head GB Bota, it appears that the then GB and the then head GB had prepared, I have my specific election, prepared another list of VCM containing the name of petition number 3, 8, 9, 14, and 15 without the consent and knowledge of the respective clan man and submitted the same to the office of ESC Gauhati. The list of new VCM containing petitioners 3, 8, 9, 14, 15 was never submitted by the respective clan man as it was done in the case of correspondence. The NHA 3, page so to the repetition clearly shows that VCM list of petitioners 3, 8, 9, 14, and 15 was prepared and submitted by the then GB and the then head GB, petition number 5 and 10. It also appeared that the petitioner, particularly petition number 10, the then head GB, has committed fraud while preparing and submitting the list of VCM in favor of petitioner, as there is no list of VCM first submitted to him by the clan representatives. Such allegations made clear from the endorsement list of Sanchu clan, where Sri Krivizole Sanchu had never endorsed / consented the candidature of Sri Vilahuile Sanchu, petition number 8, to be the VCM of Sanchu clan. In the purported list submitted by the then GB and the head GB, the name of Krivizole Sanchu has been shown as serial number 18, as if he was present and endorsed in support of Sri Vilahuile Sanchu, petition number 8. Instead, the Sanchu clan had meeting on 30/3/2021 and chose Sri Krivizole Sanchu, respondent number 11, as VCM to represent his clan, and for that he has been impleaded as private respondent number 11. It is a clear case of fraud committed by the then GB and the then head GB, Bota, illegally using the name of Krivizole Sanchu, sworn and shown to have supported the candidature of petition number 8. Similarly, my lord, even in the case of Rio clan, after coming to know that Raju Krele Rio had also attended the Rio clan meeting and endorsed the selection of Sri Tapunito Rio as VCM for the Rio clan, as his name appeared as serial number 19 in the list of Rio clan. The deponent has a personal contact with Sri Raju Krele Rio on inquiry regarding his endorsement. The latter has totally denied attending such meeting at village and his endorsement in favor of Tapunito Rio as VCM. Then the deponent suggested if he can swear an affidavit clarifying his non-endorsement, and also requested if such affidavit can be used by the deponent, to which Sri Raju Krele Rio agreed upon. Accordingly, Raju Krele has sworn an affidavit before notary public. I have shown to this honorable court, my lord. Now, my lord, this specific statement has been made, and I have made this serious allegation against the GB and head GB. Now, my lord, my humble submissions, in spite of making serious allegation against GB and head GB for committing fraud, unfortunately, the learned single judge, while passing the judgment, did not discuss the submission made by the respondents appearing for 7 to 12. Not only ignoring, there was no finding at all in the impugned judgment. Therefore, I have stated that the judgment is perverse on this ground alone. In any given case, when fraud is established, no further proceeding, in fact, will be required also. So here in this case, unfortunately, I say, the learned single judge has not taken into consideration the allegation of committing fraud by the petitioner and their agents. That was never discussed by the learned single judge, though I have made specific allegation and I have made verbal argument. Though I had advanced verbal argument at the time of hearing, this was not taken into consideration. No discussion was made by the learned single judge. No finding was given on this. Therefore, in my respectful submission, the judgment is perverse. Even just on this aspect, The judgment cannot stand. My lord, the rest, since my lord, the learned Advocate General, he has covered almost all the points. He has taken lordship to all the documents. Therefore, I adopt the submissions of AG, and with this, I sum up my submission.
Lordship, regarding the allegation of fraud here, Lordship, that has been dealt with, I replied. That is at page 225, my lord. May I kindly note down the page only. 225. Paragraph 13, there is the reply to the affidavit filed by the private respondents. Here the names were taken down, my lord. The people, there's no signature in the list. The names were taken down, the name was taken down wrongly. The person whose name was supposed to be there has also shown an affidavit and placed before his honorable court, saying that it is my name, inevitably somebody else's name was recorded. Serial number 19. That is there, my lord. Reply is at page 225, paragraph 13. Paragraph 13, page 225. Regarding the explanation regarding the name of the person appearing as serial number 19. Specifically at page 226 on 226 will be enough. Page 226.
You say it's a mistake.
Well, yes.
So far as Rio clan is concerned, you say that it's a mistake.
Lordship, yes, it was because the names were taken out by one person who has supported, and there instead of one Rosungole Rio, his name was included, and Rosungole has shown an affidavit that it is I who have supported him, but so an affidavit also has been filed.
That itself has proof that it is fraud. When they have admitted the fraud, that when they have admitted they have written someone's name.
You say that we have taken note of.
Regarding that Sancho, that one person named Sancho, initially supported the candidate of Fargus. Then subsequently he became a candidate in the next list.
One is, what is the interest of the state? If the state's officers who were entrusted with the duty after the dispute arose, they bona fide performed their duty strictly in accordance with law. Now to say that this election should have been taken place in the village, that is not even a finding by the learned single judge to that extent, that there has been an error because of that. No. In fact, at para 35, the learned single judge specifically states that you must, it is obligatory for you to conduct this verification. I've read it out to your lordships, para 35 of the judgment. So question of locate, it should be in the village, otherwise there will be this and that doesn't arise at all. Nor had he taken any such objection at the inception. He is changing the stand at every now and then. Now coming to the stand that
the reason is very simple.
Right.
Reason is very simple. In the affidavit, it is read that there is a seasonal head Gambura. Seasonal. The word is used seasonal. The paragraph which Mr. Jha was reading. Paragraph 8 he was reading. Para 8, page 155.
That pertains to clan, not GP.
No.
Seasonal chairman, secretary.
Seasonal chairman.
Chairman, that's clan with the pertains to clan, not GP.
Okay, it is a seasonal chairman. So with change of season, things can happen. We don't know.
Then, my lord, the assertion that his petition has been rejected, ours has been rejected, both the parties, so there is justice. No. His petition was rightly rejected. inter alia among many other factors. He didn't participate. There's cogent evidence to show his stand and how it keeps changing. And every now and then we are seeing a lot of insertions coming here and there. As far as the other group is concerned, they have lawfully, scrupulously followed the provisions in terms of Section 4 of the Act. Once they have gone through that Act and they have been accordingly selected, now just on the basis of presumptions, non-suiting them may not be proper. As I said, that it does send wrong signals. If there's a fault, you can say there's a fault, there's no fault. And see the attitude of this person doesn't take these things. He says, I didn't know he's a Gambura, that it was extended. Then what Gambura is? So you cannot just beat about the bush. So in my respectful submission, my lord, though the judgment of the learned single judge is a detailed judgment, many of the crucial issues in favor of the concerned parties have been ignored. And to fix them that they are the violators of law, that would not be in accordance with law. It requires to be set aside. This is my humble submission.
Where is the decision of the authorities on verification? What is which page is the decision of the authorities?
Pardon, my lord?
After verification process, what is the decision of the authorities? Which page?
After the verification process is over, it was sent to the ADC and DC, and from there to the competent authority, that is the commissioner.
Where is the order? Final order?
Yeah. This question was raised earlier also to see, because that is the second point. Approval of the government should not be at that level. It should be actually approval of the government.
Page 122.
122.
122. Read it, ma'am. Approval of the elected villages number 21. Inviting reference to subject above, I am directed to convey herewith the approval of the government of Nagaland on the proposal of the constitutional media elected government council approved the enclosed of the- Then also at both sides, page 123, my lord. Page 123, at serial number 6, we have given the names of those who have gone through, everything detailed. And 125 is forwarding of this approval by the Joint Commissioner below. It's going back down.
Just one.
Page 125.
Just.
Then to the other officers at 127. Likewise at 128.
What is this 123 you said?
Yeah, 123.
This is a list.
Yes.
This is the list of the
This is
villages.
the BCM list. And here at serial number 6, both are, because this is the list for different villages. So as far as both sides concerned, it is in serial number 6. From thereafter, it comes down in the hierarchy. It goes to the Deputy Commissioner at page 125. In 127, madam, with the EAC.
Deputy Commissioner.
Last is page 128. Goes to the GB also, the GB. So from where it comes, it goes back through the proper channel.
But Mr. K. N. Balgopal, Advocate General, assisted by Ms. V. Sukurila, additional AG, also heard Mr. M.T. Longchal and the council for the respondent numbers. Respondent number 1 to 10 and 13 to 17.
My lord, I am
And
for 18 to
Mr.
23.
Is our and it,
18 to 23.
the council correspondence 18 to 23. The argument is included, judgment is out.
What?
Now, we'll have to do an arm wrestling and arrive at a decision.
Arm wrestling. What?
Now, we take up that yesterday's, that road matter, item 1.
For admission, item number 1.
Mr. June, in this matter, I just wanted to understand a few things. The order of the Supreme Court.
Yes, madam.
It had stayed 1/4 part of the
Yes,
order.
yes,
7 except that
yes, madam.
has, what is the progress in field with regard to this road?
Yes, madam. Now, my lord, the matter in the Supreme Court is about the ROW, right of way. The contractor has approached me at the Supreme Court saying that the right of way has not been provided to him.
Correct.
Therefore, he cannot execute the work in terms of the specifications, and the deadline fixed for him is therefore arbitrary. And that is the reason why the deadline, not the deadline exactly. If the contractor did not fulfill or carry out the right percentage of work, he would be blacklisted. That was the direction.
Yes.
That has been stayed.
Hmm.
So effectively, even the deadline was stayed. Effectively, the deadline was stayed. Now, the NHIDCL by itself has extended the deadline up to the 1st of May 2024.
It was extended?
Yes, sir.
No, but
NHIDCL
just tell me one more thing. I'm just trying to understand. It's not, we are not formulating anything. We're trying to just understand. Is it possible for the state to apprise the situation to, it depends on your system of the state and petitioners here to inform the apex court about the present status so that at least the work can start.
The work is going on, my lord.
Work is going
The
on.
work is an ongoing project, it's still going on. And the affidavits have been filed showing the percentage of work done as on date.
Okay.
The respondent number 9 is the contractor. And according to the contractor, the percentage of work done is 60%. And according to the English IDCL,
This is that Dimapur.
This is Kohima Mount.
Kohima Mount. Okay.
This is Kohima Mount.
Okay.
Yes. So
But,
contractor says 60%.
But in that road also we have been informed that the road is still not in a good condition.
Which one?
From Kohima to Mao.
Yes, ma'am. It's still an ongoing project. It's not completed yet. Not completed yet. So according to the contractor, 60% has been completed. According to NHIDCL, it's just 59%. 1% difference.
So we can adjourn the matter then.
Yes, ma'am.
Because unless Supreme Court.
Actually, ma'am, unless the matter is decided, the Supreme Court.
Our hands are tight.
Yes, ma'am.
Because we can't exercise that. What you call.
We cannot issue any directions now.
We can't issue direction after that.
And NHIDCL has also extended the time frame to 31st May.
That is the clarification. Otherwise, why would I adjourn it?
Yes,
Because
ma'am.
since I,
Yes.
without understanding to adjourn the matter in projects like this,
Yes, ma'am.
It,
And this is a suo motu PI, Your Lordship, and I agree as the amicus.
yes, we are aware of it. Just. Just one more query we have.
Yes, ma'am.
Now, there is also somewhere that the land or the right of way was to give it free of cost to the NHIDCL.
My lord.
But what is happening on field? It is the state acquiring the land and giving it to the NHIDCL for without any cost, or
what is happening, my lord, is that the land is yet to be acquired. That is the issue, ma'am.
that is why it went to
This is the complication.
Okay.
And in fact, when
So,
the
but
matter
then
was first
state,
taken up,
what is the state doing then to give the right of way?
The particular case, it is the project of the NHIDC. So if they want to acquire the land, they have to approach the state.
No, no,
And
no,
they
no.
file the
Don't take
affidavit.
that stand. You can't take that stand. Because the government is on record saying that the government would give the land free of cost to the NHIDCL. That is why this right of way, handing over, taking over, all those things are arising because of that. Because if NHIDCL had to give compensation, they would have acquired land under the National Highways Act.
The thing is
Nobody
that-
had stopped them.
Yeah, Your Lordship,
But
they have
when
filed-
the state commits that they will give land free of cost to the NHIDCL,
On the earlier occasion, the NHIDCL, they have filed affidavit regarding the not acquisition of the land. And this project is for upgradation of the existing road.
you are for state.
I am for the state, Your Lordship.
Then we'll drop contempt, saying that we take so much of contempt because you
Your
went.
Lordship, yeah.
No, no, no.
I
You
will
see,
be allowed to submit.
the contractor went to the Supreme Court on the premise that right of way was not given. When you say that it is an existing road, then question of right of way would be out of question. That would be what you call what you call fraud on the face of record for an existing road. Why would you give ROA, ROW?
Upgradation and road widening. Your Lordship, here, my son is very clear. I'm only a felicitator. I have to look up to the local situation.
No, no, no. Please
Otherwise,
take
the
one
project
stand.
is-
Please
belongs
take
to
one
the
stand.
ministry.
Come one by one.
Yes.
Because we're very slow in understanding. So please bear with us and please tell us. You are saying that it's only a contract for upgradation of the existing road. Please show us that on the record. Please show us that.
may I assist Your Lordship?
Yes.
Lordship, I have prepared a brief, a written brief. It is also on record.
Yes.
All the details are mentioned there. Written brief of the amicus curiae. Lordship will come to that.
These are order sheets.
It was filed on 17th.
Just a minute. We'll to the other side. Okay, this is the order.
Brief. Brief of the amicus curiae.
Yes. This will go in 99.
Filed on 17/10/22.
17, 10, 22.
17, 10, 22.
17, 10. Yes.
Has the lordship got it? Paragraph 1.
Upgradation of existing road.
Yes. It is for the upgradation of existing road to 2-lane. So it's just not the existing road, but it is the existing road to 2-lane. So therefore, what happened, my lord, is this. The acquisition problems right away was not made available. So this was not the opinion, but the contractor. And he said a contractor, they should start constructing on the existing road, and side by side the acquisition process should go on. That was the direction.
Where did we read this? Government said that they would give the land free of cost. We read it somewhere. No, the government was supposed to give land free of cost.
That's what they say. I don't know.
No, we read it somewhere.
Yeah, what the NHADC refers to is a letter written by the chief secretary. A letter. It's not a decision of the government, just a letter.
Okay.
Which says that the government has decided to give land free of cost for the construction.
Where is that? We forgot. Where is that?
Isn't the affidavits filed on behalf of the respondents 2 and 8 on 12/4/23.
2 to 8.
12/4/23. 2 and 8. 2 and 8. 12/4/23. 2 and 8, rather.
Yes. File on.
Filed on 12/4/23.
Yes.
And the letter is at page 19 in lecture 5. It's a middle part of the letter.
Therefore, I request you to consider compensation in lieu of land.
Yes, madam. And appropriately keeping in view of our existing policy of non-applicability of land compensation on road projects. In the middle of the letter. Where existing alignments are adopted for development.
Who's for NHIDCL? You're there.
I'm representing NHADCL.
Have you taken a stand as to whether you are going for a land acquisition proceedings?
Never initiated.
No, Lordship.
But then there'll be always a what you call everything will every development will stop.
Yes.
If Lordship may kindly come to the order passed by this honorable court on
No, we are
26th
not
of
on
July,
that.
Lordship.
No, you see, we are not on that right now. We are just trying to
Lordship.
understand.
Lordship.
We have said that we will adjourn it. But
Lordship.
we are just trying to understand so that there's a clarity on what on the thinking process of the court.
Lordship.
Now, the chief secretary writes to the managing director of NHIDCL that
Yes, Lordship.
they are unable to give.
Lordship.
Now, if that be the position, either you have a meeting with the chief secretary and we'll have to sort out the issues
Lordship.
and then go proceed or abandon that project. You'll have to ask your NHIDCL to have a joint meeting with your with the chief secretary and the chief secretary for the purpose because it is his letter.
Lordship.
This has to be sorted out.
Lordship.
So do we, in the order, do we say that you will explore the possibilities of having a high-level meeting with NHIDCL and the chief secretary?
If I may,
Sorry.
Lordships, if I may, now after all this, recently there has been a decision, there has been a meeting of the state in the highest offices, and they have decided that land compensation as well as the so-called damage compensation. Of course, if a club is to get it as a compensation in terms of industrial development. So the state will follow that from now on, henceforth. That's what the state says. That decision has already been taken.
Has been taken.
Has been taken. The state can place that on the record.
Where is that?
Yes.
Has been taken.
That has been taken. Yes. Just go back to square one. Where is that affidavit of the government? Putting on record the stand of the high-level meeting.
Your Lordship, even me, I actually have not seen the notification. I have just seen reports in the media the learned AAG can be directed to place on record.
And next sitting.
Next week you will file it. All sides, including learned, Mr. AG, learned, amicus curiae are present. In course of deliberations, it appears that the work in question was for upgradation of the National Highway 29, right? 29.
And new National Highway 02. New 02. Old National Highway 39 brackets, new National Highway 02.
02. New highway, new NH 02. It appears from the DO number CSO oblique W symbolic end H oblique GEN dash 1 oblique 2020 dated 6/8/2020. The Chief Secretary to the Government of Assam, Government of Nagaland, had requested the NHI DCL, the Managing Director of NHI DCL, to consider compensation in lieu of land for Kohima bypass portion. It is the court is also made to understand that meetings have taken place between the state administration and the authorities of the NHI DCL, and some decision has been taken in this regard. Mr. Your name, please? Government Advocate.
Additionally,
Sorry, additional AG. Additional AG. Appearing for respondent numbers 1, 2, and 8.
3, 4, 5, 6, 7, 11, and 12.
Okay, just right there.
3, 4, 5, 6, 7, 11, and 12.
Submit that by filing an affidavit, the result of the bidding shall be brought on record. Accordingly, matters is adjourned today. List, just tell us when.
After 2 weeks,
Tuesday,
27th? 27.
27, okay. 27, 3/2024.
Status reports also to be filed.
Pardon
Status
me?
reports by the contractor and the NHI. Status reports in terms of the
Okay. The
execution of the contract.
the status report, in the meanwhile, the status report shall also be filed by the MHA DCL and the contractor. The affidavits shall be exchanged at least 1 day in advance.
Please, your lordships.
Just.
Your lordships, I would like to place a sincere request on whether, since by parties for submission of the authorities, and partly it has been submitted, so it can be upgraded. My lords. My lords.
I think we'll not have time for any other matters because this will take some time.
My lords.
I'm addressing the members of the bar. We may not have time. We may not have time to take up any other matters. This is going to take some time.
For hearing item number 21.
It's a partner matter.
My lords have already placed it on record. Your lordships, the two authorities have already been placed before your lordships yesterday. That is, one is 2023 SCC 443. The second that I've placed before your lordships yesterday is 2016 SCC Online Madras 18107. These two decisions I've already placed before your lordships.